Okay. Yeah, Duncan.
I'm going to surprise you all by taking the other side, because I want to, with Ben in particular, see if we can tease out some arguments. I've had these arguments even with heads of GCHQ and other people, and in the different forums where the market were coming together. And it's the ones that they put out most in the public debate, and which I find technically and legally quite hard to deal with, to articulate the response, even within that magnificent summary that two summaries that we had at the start. What they're doing is not mass surveillance. You've got it wrong. It's bulk access. Our probes go into the cables, certainly. They ingest data in massive quantities, and they take it into large-scale storage systems which hold all of it or filter it down or reduce it particularly to intelligence artifacts. We call them DNI, digital network intelligence, for the lesser amount of call records, dialed number records, DNR. It's true that we take 50 billion a day off the cables that we tap around England, the Middle East, and elsewhere. Our duty is to get, for the protection of the citizens of the states, the information that's relevant to terrorism or the categories that are specified in our enabling legislation, the broad categories. And we can't sift it in advance. We don't always know what our targets are going to be. We don't know what's going to pop up and be a real and significant threat to our radar. Therefore, we have to hold it all. It's the needle in the haystack idea. And the core principle that we've all got wrong is that there's no breach of privacy because the machines only sift the data. It goes into a machine store. It sits there. It may sit there for a long time. It may be transferred to the United States. But only if and only if a machine search is conducted under a human or automated process which sets out to meet the criteria in the published legislation, will something be pulled out and looked by a human analyst. Now, this judgment is already in the law because that's more or less how it's put in Liberty versus UK, which panel will know, but it's the European Convention case when we uncovered 16 years ago a listening tower in the north of England that tapped into all of the Irish communications of the time. The United Kingdom's still doing that. It's doing it in other cables in other places.
Duncan, is there a quick, we've got limited time. Is there a question?
The question is, why does it breach privacy to just do bulk access and sorting in that way?
Yeah, the basic position that the services take, just to summarize that into a sentence, is it doesn't constitute a breach of privacy or indeed an interference with privacy needing justification until there is some human element in the process. And therefore, since the data mining algorithms which are applied to whether it's retained data or intercepted data are non-human in character, it follows that it's only once we start looking at the product that's generated from that there's any privacy issue arising. It's rather like one of those Friedrich Escher drawings that depends on whether you're standing in one position or another to see which way the perspective is directed. I mean, at the end of the day, one of the first questions to ask here is there a reasonable expectation of privacy on the internet, yes or no? And as soon as you have a system, the implications of which are that any communication may be the subject of surveillance, there is no longer any secure method of communication which is immune from government intrusion. So to my mind, that's why I said earlier on, it may be an attenuated version. No one is suggesting that every email that anybody sends to anybody else is being read and considered by human intelligence any more than the selective advertising down the side of your Google Mail is the result of somebody reading your messages and giving you adverts that are directed towards your purchasing profile. But if the consequences of the systems that are in operation, that there is no right to privacy on the internet, in the sense that no one can assume that their communications are closed and confidential, then that is what needs to be justified. So it's absolutely right that their analysis is this is looking for a needle in a haystack, and we do it in a combination of an automated way and human intelligence. But where they part company from me and from, I think, the UN, is that the suggestion then is all we need to justify is the needle. Whereas what we would say, and what the High Commissioner herself has said in terms, is that what these programs and the authorities that back them need to justify is the surveillance of the haystack.
Any more questions? Hopefully there are.
Hi. Now, forgive me if I'm making any of the legal principles wrong, but you said that proportionality, there has to be a public debate, so to sort of work out where the judge will draw the line. So without this kind of informed public debate, does that mean that the decisions that the sort of tribunals are coming up with, and perhaps even the European Court, would not de facto but de jure invalidate their sort of decision making?
It depends on the specificity of the evidence that's put forward by the government concerned. I mean, it's a staged analysis. The first stage is looking at the quality of the legal regime, and that's the subject of the decision that was touched upon earlier on from the IPT, which has been focused on the quality of the legal regime. Once you get onto proportionality, then depending on which tribunal you're in front of, what is required is a sufficiently calibrated and evidence-based analysis which can justify what is actually going on. So there's two stages to the inquiry. Stage one: what is the degree and nature of the internet penetration that is involved? Stage two, is that justified? And you can't justify it by reference to generalized invocations of national security, counter-terrorism, and a suggestion that this type of technology may provide support or assistance in pursuing those goals. In order to get a calibrated and rigorous analysis of whether the proportionality test is satisfied, states have got to cough up their justification. I mean, putting it really crudely, it's no good the head of GCHQ coming up and saying to the Home Affairs Select Committee or to the Intelligence and Services Committee, as he did, we can assure you that this has been of vital importance in our fight against terrorism, because this is a huge paradigm shift in our understanding of the relationship between the individual and the state. Even the US Privacy and Civil Liberties Oversight Board recognized that these programs involved a significant shift in the relationship between the individual and the state, and that demands a sufficient justification so that people know what is being done on their behalf.
Can I add just briefly, excuse me, sorry, can I just add briefly to that? Just to demarcate our position, Privacy International differs slightly from Ben's take on proportionality, and with the greatest respect, I think we're coming from slightly different positions in that we're an activist organisation advocating for pushing the norms, whereas Ben's doing the very noble job of assessing what actually the norms are. But we would certainly adopt the position that mass surveillance could never be proportionate, no matter how it's justified, even in a public debate, given the indiscriminate nature of the surveillance itself and the very, very high risk that creating massive stores of data create, as the European Court of Justice have said. Our position is that it could never be proportionate. Now, Ben has rightly said in his report that's not the case yet under international human rights law. We've not had a court, a tribunal, say that mass surveillance is inherently disproportionate, but we would like to think that that's where the international norms will go on this eventually, and that's certainly the arguments that we're making.
One of the most disturbing implications of this is surely the violation of the relationship between clients, between lawyers and their clients, particularly in cases related to the state. So I'm just wondering if you have any evidence of that, if it's had any impact on any of your cases, whether you see that as a major threat, and what kind of working practices you have to address that.
very briefly, there has been a case in the Investigatory Powers Tribunal that Reprieve, who was already involved in litigation against the government on behalf of a Libyan family whose son was rendered by the UK security services. So they had ongoing litigation, found out about the Snowden revelations, realised, of course, that this means their communications with their clients and their families are being swept up in tempora, and brought a case on exactly that point. Now, they've had extensive disclosure in the last few weeks from the UK security services showing that, of course, legally privileged communications are intercepted, albeit in the context of some processes and protocols that the security services are applying to those materials, but I'm sure all of us would agree completely insufficient ones. So I think there'll be a judgment on that, and I assume there will be a continued challenge along the lines of Gavin's arguments around confidential sources in the journalistic world. In terms of changing practices, it's something we've been talking a bit to the Law Society about, actually, and our lawyers that we're working with and in various barristers' chambers. I mean, none of them have encryption, of course, and but it is something, I mean, perhaps Ben and Gavin can speak from their own experiences, but we've had increased requests from our lawyers and barristers to teach them how to use GPG, but I mean, really there are quite high costs, I think, for them to adopt those processes, as we all know. So I think that's hopefully where we'll see that industry going as well, recognising now the implications for their, very serious implications for their own work.
I might add, so in the United States right now, the National Security Agency has, I guess, there's no formal accountability, but it's kind of overseen by guidelines by the Justice Department regarding harm minimization that ask the NSA to minimize surveillance, and there's one paragraph regarding attorney-client privilege communications, but that statement only applies to attorney-client relationship after somebody's been indicted. So if somebody's been indicted for a crime, then the NSA has to take measures to minimize the surveillance. But there's a very gaping hole in that. What if you're a client who hasn't been indicted? So what if you're a client under a criminal investigation, under a grand jury investigation, but you haven't yet been indicted for a crime? Or you're simply retaining an attorney for advice. These harm minimization guidelines were actually signed by Eric Holder, meaning he put his imprimatur on these guidelines, which I've spoken to several attorneys that are in agreement that this is highly unethical, and we've considered measures against this in the United States, because it's basically saying, implying that there is a right for the NSA to spy on protected attorney-client communication, which is very problematic. And as Carly mentioned, a number of organizations, my work, I make sure to make technology be a key part of the work, because I can't rely on the fact that the attorney-client privilege on paper is going to protect me. That would just be naive, and I would actually argue that's unethical for me as an attorney with knowledge of the surveillance taking place to not adopt technical measures to prevent that. So my background actually before law was in math. I have 2 degrees in math, and I'm actually very passionate about the technical side of these issues, and I train other lawyers in security, and it's a very important part of my work. But I absolutely agree that it's a fundamental part, because it undermines fundamental protections of our system. So.
I was wondering, you made it clear that a general consensus, sort of a global consensus, to create laws that would oppose the surveillance state would be impossible. But seeing as they're a global operation and they have the Five Eyes, isn't that a catch-22 and a kind of oxymoron between how we would begin to approach these systems?
What I was trying to convey is that efforts that are directed towards trying to promote an international treaty or an international agreement to regulate internet privacy are doomed in practice to fail. I mean, we can talk about it, and we have these resolutions that come up now 2 years running, and they will continue, and it's great that it remains at the top of the agenda. But those who are interested in promoting the development of new laws, either through legislation or through court judge-made law, need to focus their attention on tackling the states that are doing it, rather than on trying to promote generalized international standards, because even in the most unlikely event that we got a resolution of generally agreed international standards, they would be diluted to such a level of generality as to be virtually meaningless. I mean, you can look at the two resolutions from 2013 and from last month from the General Assembly. I mean, they are, in a sense, international agreements. They are resolutions of the UN General Assembly. But they say things like, you know, we should all ensure that international law is met and is discharged in the interception of digital communications. They're at that level of generality because, as with all international negotiations, you get a resolution which reflects the position of the state willing to go least far, and that's the way it works. Whereas much more effective activism, legal activism, is taking place as we speak. I mean, every speaker to my left is directly engaged in bringing challenges before courts and tribunals nationally and regionally, which do have jurisdiction to do something about it. Now, if at the end of the day the European Court of Human Rights shirks its responsibility to do something effective in this area, then, you know, heaven help us all, because that will be the result of them having been persuaded on evidence, probably solely open evidence, there possibly some closed evidence as well, that this is a justifiable and proportionate way forward. That, in other words, that we no longer are really entitled to enjoy the right to privacy on the internet. And that's a possible outcome. But, you know, recent history has shown that court has been prepared to be pretty muscular in some areas where you'd normally expect any national or regional court to shy away. So, I mean, the ECHR is the only court, for example, that has held the United States CIA liable for its involvement in rendition and torture of terror suspects. There's it's a good politically motivated court with a human rights bias, and that would be the place that I would focus my attention.
Yeah, I agree with that. There is one decision called Telegraph Media versus the Netherlands under Article 10 in Strasbourg, where the Dutch government tried to sidestep the procedural protections for journalistic material that might identify sources in a case where they'd been spying on two journalists who'd written stories about police corruption and organized crime on the basis of leaked material, and there was intrusive and directed surveillance against them. They were being bugged and they were being followed, and it was authorized by a senior officer of the security service, possibly a minister. It wasn't really clear on the evidence, but certainly not a judge. And Strasbourg said, absolutely not, you can't do this. It's too important, the protection is too strong to have decisions taken at that sort of level. So I think there is a lot of mileage in bringing cases to Strasbourg. I ought to also say that we have got an IPT case for the domestic use of REPA against journalist sources, which I think is going to come up in March in front of the same tribunal that your case was heard in front of. I'm not wildly optimistic about the outcome, but it is a sign of the times that one of the big mass circulation media groups is prepared to take a case and ask for an open hearing against, as it happens, the Metropolitan Police, to ask them how they use these powers against journalists and how they would justify using them against journalists in a case where they have admitted in a public document that they use the powers against the journalist. That time, I don't know.
We are now a few minutes over time. I do have one person here who has been repeatedly putting her hand up.
Let's do one more.
It'd be nice to have a female voice for a question too. I'll hand that over and then perhaps you could sum up for me.
I just had a couple of questions. First was, have the authorities attempted to justify using RIPA rather than the PACE safeguards in terms of access to journalistic material? My second question is, if the government continues to push that the only avenue around the changes to the current framework in the UK is to consult on the code of practice, will that be sufficient enough to be able to introduce judicial oversight to the powers, or will that require, for the procedure to access journalistic sources and communications, would that require primary legislation? Because at the moment Theresa May is insisting they're only going to consult on an updated code of practice. And thirdly, other than waiting just for that consultation on the code of practice, what other opportunities are available for campaigning and making alliances around changing the law in terms of the shield law that Gavin's proposed?
Well, the short answer to the first question is they haven't sought to justify using REAP powers rather than PACE. I think the reality of this is that in the last 5 or 6 years, there has been case law created under PACE. This is the Police and Criminal Evidence Act, which allows applications in police investigations for journalistic material, including material that might identify a source, to be made in court in front of a circuit judge, and for there, in most cases, to be argument and a right to be heard on behalf of the journalist or the media organisation. There have been cases recently about that method of accessing journalistic material, which have been very pro-journalist and have recognised and respected the Article 10 protections. And I think that the cumulative effect of those cases is the police just became fed up with trying and losing, or just thought it was all too difficult to put a cogent case together to go before a judge to get access to confidential journalistic material. They had a go at the end of the Leveson inquiry in the Met in making a submission to Leveson when it was kind of free-for-all and everyone was asking Leveson for recommendations for all kinds of legislative amendments to hammer the press. The Met had a quick opportunistic go at amending PACE to make it easier for them to get material through the courts. And there's a consultation on that at the moment. But I think basically what they realized progressively was, why are we wasting our time doing it through this judicial mechanism when we've got REPA? And so they migrated their efforts to REPA, and I think it started to happen a lot in the investigations into phone hacking, in the investigations into payments to sources that are all coming to court now. I think they got a lot of REPA material through that, and that's the way they think you do it these days. It's as simple as that. But when asked to justify, no, absolutely they don't. Primary legislation is required because you have to find a way of forcing the decision before a judge. You have to push it to a judge. And there is simply nothing in REPA that requires that at the moment, except for certain kinds of surveillance, like intrusive surveillance. For my own part, I'd like to see that the legislation not only require the application to go before a judge for a presumptive right of audience to be given to the journalist so the judge can hear the other side of the case, and for the criminal procedure rules to set out a formal procedure, as in PACE applications, for those sorts of applications to be made. I think there is a groundswell of support building for this amongst journalists. The problem always is the politicians. Let's face it, in all of these cases of amendments of laws, you go to parliamentarians and you get some very sensible and well thought out contributions in the House of Lords. Not that I'm a proponent of the House of Lords, but it does engender a higher quality of debate these days on these technical subjects than in the Commons. But it's just extremely difficult to get MPs interested in this sort of stuff unless there's a vote in it. And usually there isn't a vote in this sort of stuff. So what you have to do is find cases and get them into the newspapers of journalists' material being accessed. They do get into the newspapers. The problem actually with the press campaign, particularly run by the Press Gazette, but also by a number of the other newspapers, following the revelations about Operation Alice and Plebgate and the Hume cases, they ran out of examples of the police doing this. Now, there are loads of examples, and what we need are police whistleblowers to come forward and start revealing the other cases in which they've accessed this material and used it in the investigation, because it doesn't surface in the court case. It very rarely surfaces in the court case that they've done it. And then the politicians will start to take a bit of interest. You know, if it's your constituent or somebody who writes newspaper articles of the sort you approve of, then they might take a bit of political interest. You might get some momentum going. But I have to say the political response to it on the whole has been pretty abject. And the influence that the securocrats, as they're called in Parliament, have over decision-taking in Parliament is huge. I mean, it's not to be underestimated. And I think one of the problems is that, and I've had this from an ex-minister who said, look, you've got to realise the moment you come into office as Justice Minister or something, they come and see you and they say, you know, you think you know all about this, but you don't know what we know. And if you knew what we knew, you wouldn't risk all this sort of stuff, giving all these rights away and hindering our capability. And do you really want to be the minister who allowed a 7/7 to happen and for us later to have a public inquiry and reveal that we didn't have the powers to stop it? And this minister said to me, well, what do you do in that position? You know, do you stick by your principles, or do you take a pragmatic political decision to go along with them? And I'm afraid too many of them do. So there's this kind of tension, and there's this struggle going on at the moment between we need it and we don't need to justify it, and rights proponents. And I just wanted to say finally, to finish, if any of you can, it's very important that we keep the publicity in place and flowing about the progress of these cases and arguments for law change, because the other side are constantly, the securocrats are constantly getting publicity. You will notice recently, although they don't tell us when they use these methods and they fail, when there's a chance for them to say, oh, we foiled a plot, you know. We foiled a plot in West London. There was a raid and we took 8 young Muslim guys into prison, and we were looking at their emails, and it was terribly serious. And hint, we wouldn't have been able to do this if all those Guardian readers out there had their way and prevented us using these powers. And they're doing more and more of that these days. And it's no coincidence. This is the PR backlash against Snowden. And while that is going on, to try and grab public opinion back in their favor, it's very important that the momentum that was built up while the stories were being published and the cases were first being brought isn't lost, and we can keep these issues in the public eye. So anything you can do as journalists to help with that is very important. Thank you very much.
Thank you very much for